First case the court's going to call is 2018-250, State of Arkansas versus Tyler Sutterfield. There's also a revocation case under the number 2017-291.
May I approach, Your Honor?
Court makes the appointment of the Public Defender's Office. Representative Sutterfield, and then on motion of the state, case 2018-250 is court grants the state's motion to nullify.
Your Honor, there's also a revocation of the same resolution on the revocation also.
Petition to revoke in 2017-91 will be dismissed. Court would call 2018-256 State of Arkansas versus Kevin Burch.
Morning, Your Honor. Bill James for Mr. Burch.
This matter is for arraignment today on charges of furnishing prohibited articles, a Class B felony, and delivery of methamphetamine or cocaine, Class C felony, as well as criminal conspiracy charge, Class C felony, and unlawful use of a communication device, a Class C felony, in proximity of the enhancement provision for proximity. On those allegations, how does the defendant now plead?
Your Honor, we waive further reading, plead not guilty, and ask for a jury trial.
Court is going to set this matter by scheduling order. We'll set it for jury trial the week of January 28th, 2018. We're setting it for a plea deadline in the scheduling order will be January 24th of 2019. I said January 28th, 2019. That's the week of trial. The 24th is a plea deadline. It'll be set for a pre-trial. The pre-trial motions will be set for August 2nd, the week of August 2nd, or on August 2nd, excuse me, and that'll be the order that's being entered at this point. His next appearance in court will be August 2nd. Do we need to address bond?
Not this time, Your Honor. He does. He is signed for a parole revocation, so I understand he has that in front of him.
All right, very well.
Your Honor, that's all I have before the court. May I be excused?
You may be
Thank
excused.
you, Judge.
Good to see you. Court is calling 2018-255, State of Arkansas versus Andrew Meyer, and then 2018-60. It's the first appearance on a revocation in the latter case.
Your Honor, Mr. Meyer, when I spoke with him on Tuesday at the jail, he's been a client of ours, as the court knows, very recent client. Andrew, we don't have an application yet. Have you filled out another one yet?
Yes, I filled one out. I'll fill out another.
Your Honor, I would feel comfortable in his situation, to my knowledge, has not changed, and going ahead and entering a plea of not guilty to his new charge. And we'll see where the paperwork is, and if we can't find it, then we'll go to the jail and have him fill out new paperwork.
PD will be shown as the attorney of record on both the revocation and on the newly filed charges. So the court's noting a plea not guilty on 2018-255 and not true in 2018-60. The latter will be set the revocation case will be set for trial July 12th. Set for trial or hearing, actually, on July 12th. the new charge is on Judge Putman's docket. I'm setting it down for a reappearance in front of Judge Putman on June 28th.
Your Honor, given the conversation at the bench, defense will not raise any issue of bond at this time.
Very well. Mr. Meyer, your next appearance in court will be in front of Judge Putman on June 28th on your new charge. Your revocation hearing is set for July 12th. You may be excused at this time.
Yes, Your Honor.
(2018-259) State of Arkansas versus John Lewis. Mr. Lewis appears for arraignment on charges of possession of a controlled substance, Schedule 1 or 2, Class D felony, possession of drug paraphernalia, Class D felony, obstructing governmental operations, a Class C misdemeanor. Although, Mr. Lewis, have you made any arrangements to be represented by an attorney?
I haven't had a form filled out. I haven't filled a form out, no, but I'd like to get one filled out and get this resolved as quick as possible.
All right. It will help immensely if you're going to apply to the public defender's office, if you get that form filled out and start the process there. Your case is on Judge Putman's docket, and the court is setting it for reappearance in front of Judge Putman on June 28th. That's a week from today.
Okay. I got the form now. I'd like to sign next week if I could. If the public defender will come and see me. Thank you.
All right. You'll need to get that filled out and turned in. 2018-254 State of Arkansas versus Joseph Birmingham. Mr. Birmingham, you're for arraignment at this time on charges of possession of a firearm by a certain person, possession with purpose to deliver a controlled substance, Schedule 4 or 5. Both of those are, the first one's a Class B felony, the second one's a Class D felony. Possession with purpose to deliver methamphetamine or cocaine, that's a Class C felony. Possession with purpose to deliver a Schedule 1 or 2 controlled substance, Class C felony. Possession with purpose to deliver Schedule 1 or 2 controlled substance, Class C felony. Possession of drug paraphernalia related to the manufacture of methamphetamine or cocaine, Class B felony. And possession of drug paraphernalia, a Class D felony. On those charges, how do you now plead?
Not guilty.
Noting your plea of not guilty, have you made any arrangements to be represented by an attorney?
I need to fill out this public defender form.
All right. The court would just advise you have an absolute constitutional right to an attorney. What that means is you have the right to go out and hire the attorney of your choice. As long as you're hiring private counsel, the court doesn't get involved at all. It's a matter of private contract between you and the attorney you choose to hire. However, if you feel you cannot afford to hire an attorney, you're still entitled to an attorney. At that point, we're talking about court-appointed attorney. In order to secure court-appointed attorney, you have to first take the initiative to file or to fill out the application and sign it. Those applications are available there at the jail. Get that turned in as soon as possible, and it will get into the hands of the public defender's office and get before a judge. Not necessarily myself, but some judge to review it and make the appointment. So the sooner you get that done, the sooner the attorney will get appointed. I'm going to direct at this point. You're on this court's docket. So we're going to set it by scheduling order today. We're setting it down by scheduling order for review hearing to check on the status of the case will be set on August 2nd. We're going to be setting it for pretrial on November 1st of this year, and then for a plea deadline on January 24th of 2019, and trial during the week of January 28th. That will be the all those dates will be in the scheduling order that's entered in this matter, and it'll be entered today. That scheduling order will also include language that advises you that it's your responsibility to get in touch with and stay in touch with your court-appointed attorney. What that means is is just what it says. It's your obligation to get in touch and make arrangements to communicate with your court-appointed attorney. If you bond out, then if you're in jail, the Public Defender's Office will be in touch with you there. If you bond out, it is your obligation to contact the Public Defender's Office, schedule an appointment as soon as possible, and get in to see the attorney so the attorney can start working on your case.
Yes, sir.
At that August 2nd hearing, if I find out that and you're ordered to do what I've just told you to do.
Yes, sir.
So on that August hearing date, if you fail to appear, if you appear but haven't made contact with the Public Defender's Office, I will be in the position where I can hold you in contempt of court if you haven't done that. So please understand, I don't want to do that. I'm simply putting that provision in there so that to encourage you to get in touch with the Public Defender's Office as long as you're applying for their services and utilize their services. And you can best do that by getting in to see them. All right?
Yes.
All right.
Yes, sir.
You may be excused at this time. 2018-248, State of Arkansas versus Hayley Marie Franks. The court has reviewed the petition and will appoint the Public Defender's Office to represent. Ma'am, do you go by Ms. Franks or Ms. Sullivan?
Sullivan. I'm booked in as Sullivan, but it's Franks, really.
Well, that's what I'm asking you. What name do you go by?
Franks.
Okay. I'm gonna I will address you as Ms. Franks then. All right. Court is making the appointment of the Public Defender's Office to represent Ms. Franks and for arraignment on the following charges: possession of drug paraphernalia. That's a Class A misdemeanor. Possession of controlled substance, Schedule 4 or 5, Class A misdemeanor. Possession of drug paraphernalia, Class D felony. And possession of controlled substance, Schedule 1 or 2, that's a Class D felony. On those 4 charges, how does the defendant now plead?
Your Honor, Ms. Sullivan enters a plea of not guilty to all charges.
Court is setting this down. It's on the Division 4 docket, so the court will set it down for trial by scheduling order for a reappearance on August 2nd, pretrial motions on November 1st, January 24th, 2019 is a plea deadline date, and the week of January 28th of 19 is a trial date during that week. Are there any other matters to be addressed at this time?
Your Honor, I would ask that she be transported over this afternoon. She has 3 other cases, and I think that there's at least a chance we could dispose of all 4 cases this afternoon.
All right. I'll direct that Ms. Franks or Ms. Sullivan be brought over for the afternoon session of court. Court is calling at this time 2018-206, State of Arkansas versus Samantha Weidman. Court will also call 2017-363, same defendant on in both cases it's for first appearance for arraignment on new charges, and then on a petition to revoke filed based on the new charges in the other case. Court is making the appointment of the Public Defender's Office to represent Ms. Weidman. Ma'am, have you made any I've just appointed the Public Defender's Office to represent you on the charges against you in the new case, which are possession of controlled substance, Schedule 1 or 2, Class D felony, and possession of drug paraphernalia, separate Class D felony. On those charges, how do you now plead?
Your Honor, the defendant enters a plea of not guilty.
On the allegations contained in a petition to revoke in case 2017-363, I guess I need to go just a second. In this case, the petition to revoke was filed May 21st, 2018. It contains the following allegations. It was alleged that on May 14th of 2018, Ms. Weidman committed new offenses of possession of controlled substance, possession of drug paraphernalia. Those are the new charges in the 2018-206. In addition, her possession of drugs is a separate violation of a term and condition. There's an allegation of association with felons engaged in criminal activity. There's an allegation of failure to pay fines, fees, and costs as ordered by the court. All of those are the allegations in the petition. On those allegations, how does the defendant now plead?
Your Honor, she enters a plea of not true to all allegations.
I'm reflecting the Public Defender's Office is appointed in both these cases. Pleas of not guilty and not true have been entered. Court's going to set the revocation petition down for July 12th, and is setting the
Your Honor, is that revocation, not Judge Putnam's?
Oh, I guess it could be. I should go back and make sure. Whether it isn't, I just tried to. You're absolutely correct. I will withdraw that setting, set her down to appear before Judge Putnam on June 28th to get on his scheduling order for a revocation. On case 2018 206, we're setting that matter down for trial again the week of January 28th of 2019. For the plea deadline of January 24th, we'll set it for pretrial hearings on November 8th and a reappearance on August 2nd. Any other matters to come before the court?
Your Honor, there is not today. The revocation, being that it's in front of Judge Putnam, there is a no bond on the revocation. I would assume that Judge Putnam would be the judge to address the bond issue on that next Thursday.
Yes.
So there is nothing further today, Your Honor.
I'll leave it there. You may be excused. 2014-168, State of Arkansas versus Robert Weaver. All right, this is down for a revocation hearing. No, this says first appearance.
Your Honor, it is a first appearance. I spoke to Mr. Weaver. He's supposed to file an application. We don't have it. Have you filled it out, Robert?
I have it right here, Your Honor. I have it right here.
All right.
I have not filled it out. I tried to get one yesterday, and they got too busy here at the jail to provide me with one.
All right, let me go back. Has there been a new petition filed?
There is a petition filed. There's also an amended petition filed, Your Honor.
Well, I have a sentencing order that I signed earlier this week.
Your Honor, after he was sentenced, some issues took place and there was requests for some testing to be done pursuant to those terms and conditions. Mr. Weaver did not feel like he should comply with those terms and conditions, and so we filed to revoke him, Your Honor.
Yes.
Your Honor, may I address the court, Your Honor?
Robert?
Well, I'm trying to see where the documents have caught up with these events. I see they have not. I'm now looking at the petition to revoke. So this is a first appearance on a petition to revoke that was filed on June 12th of 2018. That the allegations contained in the petition to revoke alleges that on June 5th, Mr. Weaver refused to submit a sample of urine analysis as requested. On those, are you representing Mr. Cooper?
Your Honor, I assume as soon as he fills out an application, we will, so I would enter a plea of not true.
Okay, get that application filled out and turned in so the public defender can proceed on the allegations contained in the petition. How does the defendant now plead?
Not true, Your Honor.
Plead not true. This matter will be set for hearing in front of the court. I'm going to set it for July 12th.
Honorable Judge Webb, may I please address the court?
Well, you've got an attorney who is prospectively going to be representing you. You need to be cautious of what you say. You have a matter pending before me, and what you say may well. I'm not going to hear it today. I've set it for July 12th. I'll listen to you if you want me to, but I just caution you. The matter, whatever you say, can be considered against you. You'd be well advised to consult with your attorney and listen to him.
Your Honor, we have visited at the jail, and I think I know exactly what Mr. Weaver is about to say. I am going to advise him that he needs to stay silent at this point.
All right. Yeah.
Your Honor, I'd rather go ahead and let you hear what I have to say.
Well, that's your choice.
Whenever they pulled me out of the cell, I was in an isolation cell because I was jumped by about 3 guys 2 days in a row whenever I got in here in the C-pod. And over some stuff that did not take place. I can sit here and give you a big sob story, but they pulled me out because they thought that I was using drugs. And I did take a urine sample test, and I passed that urine sample test. They came back later on in the afternoon wanting me to take another one in a styrofoam cup, and I said no. I did pass my the test. It was right there in front of me. It's right here on the cameras at the jail, Your Honor.
Okay. As I said, the matter's in front of this court. It's set for hearing on July 12th, and we'll hear it on July 12th. I'm not
Yes,
going to
sir.
make a decision just on what you say here over the video today. So,
Yes, sir, Your Honor. I
Advised
just
by
wanted
your
to let the
counsel.
court be known.
Pardon?
Thank you, Your Honor.
All right.
You guys have a good afternoon. I'll have that application over. I'll fill it out today. Okay.
Sooner the better.
Thank you, Judge Webb.
You may be excused.